What's up, everybody? Welcome back into a case we've paused on for a little bit, but a lot of stuff is happening. Whether it's Hannah Gutierrez Reed, Alec Baldwin, this Rust trial in these cases have not been short on fireworks. And the prosecutor, Ms. Morrissey, has continued to double and triple down on her stance. Nobody understands this case except for her. Nobody understands the evidence except for her. Nobody tells the truth except for her. And we're going to read through one of her motions that she's filed in a litany of motions saying those things and blaming everybody else and saying everybody, including the judge, got it wrong. But we're going to read through the motion and hear what she had to say about Alec Baldwin and his defense team, how they've handled the case, how they've handled the media, and what they've done. I mean, some serious accusations are flying in this document. We're going to look through it together. We're going to answer your questions. Let's get to it. So this is the state's response to the defendant's motion to dismiss. That was about 5 days ago. I think the judge has already granted the defendant's motion to dismiss. There are no issues here that are going to be surprising or things that are actually going to change the judge's mind. But in that context and with that, 2020 vision looking backwards, knowing how the judge ruled, knowing what the judge felt, knowing what the judge thought, we all watched it together. We all reviewed it together. We saw the case get thrown out because of a Brady violation, basically prosecutorial misconduct between them and the law enforcement and how they handled evidence and documents and interviews and body cam footage and statements. All of the above they handled inappropriately and just did not provide things over to the defense. Now, how big of a deal was it? We don't necessarily know. It at least could have been something good for the defense. Those arguments are made. We're going to read a bunch of this document. It's like 32 pages. I think I'm going to read 22 of them. We're going to skip where she goes over the facts for the fifth time and recites the facts as she sees them. We already know because we watched her testify under oath, which, in case you don't know, is never good for a prosecutor when you're trying to case, when you're sitting on the witness stand, getting grilled by the defense attorney and the judge. And that's why it ended badly, as half of her team walked out. So let's take a look now at this document. Comes now, State of New Mexico, by and through Special Prosecutors Carrie Morrissey and Jason Lewis, who submit the following in response to defendant's motion to dismiss the indictment. Defendant's motion to dismiss is a predictably false, misleading, and histrionic misrepresentation of the facts and circumstances of the history of the case. Now, sometimes lawyers are right when they say things like that, but I kind of think it's funny knowing that she has lost, is going to continue to lose, and nobody really sees it the way that she does, yet she uses this hyperbolic language throughout. The two special prosecutors who have been assigned the prosecution of Mr. Baldwin have experienced near countless lies and manipulation from the defense for more than 1 year. In addition, we have and certainly will continue to be the subject of the defendant's contrived and unwarranted personal attacks, not just personal attacks, Ms. Morrissey, but lawsuits. You better believe lawsuits are coming. And at this point, she's throwing caution to the wind and like, forget it. Who cares? This case is over as far as the criminal prosecution goes. She's not going to have to work with these lawyers anymore. She's going to fire shots. Now, I have a feeling things like this will be cited in some of Alec Baldwin's civil complaints and civil cases, but we'll have to wait and see. The primary goal of Mr. Baldwin and his counsel, which now numbers 8 total attorneys, as if that's wrong, right? You must be doing something wrong if you have 8 lawyers. She lists out the lawyers and where they're from. And she says local counsel who, despite her reputation for hard work and competence, has been relegated to largely menial tasks because these big New York lawyers and Texas lawyers are just putting her in the corner, basically. And what these 8 lawyers are doing is ensuring that the case is not heard on its merits. And if it is heard on its merits, to discredit the prosecution, investigation, and witnesses in the media so that a conviction becomes unlikely for reasons that have nothing to do with Mr. Baldwin's criminal culpability. So basically accusing them of using the media, using his celebrity to discredit people and hit people in the media so that he can win even though he's guilty. That's basically what she's going for here. So she goes on to say, it is the job of the special prosecutors to investigate the case and fairly and impartially prosecute the case, and we will continue to do so despite the defendant's relentless attempts to discredit and manipulate the prosecution and the courageous witnesses who continue to participate in the struggle for justice for Helena Hutchins and her family. Given the exhaustive nature of the defendant's motion to dismiss, we will begin the response by providing a recitation of the factual and procedural history of the case as we know it. And that's the part we're going to skip. As for 10 pages, she just kind of goes through what happened in the shooting, what's happened in the case. But we're going to jump back in where they start to discuss Baldwin and his team, the arguments they made, some of the wins they got, right? Some of the dubs, because there definitely were dubs for Baldwin and his team throughout this case as we read throughout. But so much background information that we weren't privy to that, is it true? Is it not? Who the heck knows? We have multiple people giving their point of view. While there is merit, she admits, to the defendant's assertion that he was incorrectly charged with a firearm enhancement, and Ms. Reeves' position as a state legislator may have precluded her from serving as a special prosecutor, those were innocent mistakes that were quickly cured by the dismissal of the firearm enhancement and Ms. Reeves' resignation. Yeah, quickly and easily cured. After the defense put up a huge fight, the media caught wind of it, called it out. That is why all of these corrections happen. Not because the state did it on their own. Think about it. If the defendant would have never said anything, maybe if he had bad lawyers, that enhancement might have stuck and he could have gone to jail for 5 extra years. It's not like the state figured it out and did the right thing. It was because good defense attorneys fought hard for their client. Maybe that's why he needs 8 defense attorneys, because of all of the problems in this case. And she even agrees that has merit, but it's just an innocent mistake, people. Lives and liberty are on the line, but it doesn't matter, I guess. It's just an innocent mistake. Which is interesting thinking about this case, right? And how it's a negligent act at the end of the day that we're talking about. And while some mistakes she's okay with, others she's not. Now, was one an innocent mistake? We'll never know. Never is going to get to a jury. It was a lethal mistake, no doubt. Was there criminal culpability because of her actions? We will never know. Any allegations that the former prosecutors engaged in any unethical disparagement of Mr. Baldwin by providing limited statements to the press is legally unsound. I disagree. As has previously been litigated in the case against Hannah Gutierrez and during the Baldwin grand jury litigation, the media contact by Miss Carmack Altweiss and Miss Reeb was not unethical or unlawful, as it was done in response to Mr. Baldwin and Mr. Bold's own public appearances and misleading statements to the press. So it's like, nuh-uh, we didn't, you did. That's basically what she's doing. Mr. Baldwin made numerous public appearances to spread misinformation about the case, to protect his already tarnished public image and try to sway the public and future jury in his favor. So calling it already tarnished, that's a pot shot. You can't get around that. She's taking shots at Alec Baldwin by saying his reputation was already tarnished. As discussed above, and again, those are things I would clip out if I was suing them for malicious prosecution and prosecutorial misconduct. I would clip that. As discussed above, Mr. Baldwin appeared on national television on December 3rd, 2021, and shamelessly lied about his conduct and blamed the victim for her own death. By the way, she has no conviction to back up. This is not res judicata. This is just her opinion that he lied. Inconsistent statements can be mistakes. They can be innocent mistakes. They can be misunderstandings. But the jury didn't find that he lied and then convicted him. On August 19th, Baldwin again used his celebrity status to sway public opinion concerning the details of the investigation into the death of Helena Hutchins by appearing on CNN for an in-person interview with Chloe Melas. On August 1922, Mr. Nikas, who's one of Baldwin's attorneys, appeared in an interview with Chloe Melas, I don't know how to say that, prior to any charging decisions against his client being announced by the DA's office. Mr. Nikas said that any criminal charges against his client would be a huge miscarriage of justice. Well, I got to be honest. I was kind of seeing both sides of this as we went. I could see if somebody would find this criminal. I could see if they didn't. But it's over now. It's not criminal. He's not going to get convicted. So it looks like a miscarriage of justice at this point. A prosecutor is not required to stay silent under these circumstances. She was permitted to rebut the parade of misinformation spread about by Mr. Baldwin, his counsel, and counsel for Ms. Gutierrez. The New Mexico rules of professional conduct say a lawyer shall not make any extrajudicial or out-of-court statement in a proceeding that may be tried to a jury that the lawyer knows reasonably should know is false or creates a clear and present danger of prejudicing the proceedings. And then she cites some more language on when you can and can't make extrajudicial statements, saying they didn't violate any of the like. Reese's mom says, I'm confused. Didn't the judge dismiss the case with prejudice? What is the purpose of this? Well, she's trying to say the judge made the wrong call, but if you really read this as we're going to today, it's just like Miss Morrissey taking the stand, knowing she was going to lose, knowing this case was going to get thrown out, knowing she violated Brady. She wanted to tell her story and say her piece, and that's what I feel like this document is. Why are people up in arms about Morrissey but not YSL? Listen, when you say people, I hope you're not including me, because I am. The stuff that's happening in YSL's case is worse than in Morrissey's case. But here's the difference, and this is a good learning moment. Thank you for this question, Busy the Gamer's mom. The difference, I think, that we're seeing, and people can say it has to do with maybe with race or things like that. If you want to say that's the difference, okay. That's not how I see it. How I see the difference in this case is generally the public wasn't sure if Alec Baldwin was really guilty of a crime. They didn't, or some of them just didn't think he actually committed a crime and what he did was not criminal. And so it's a lot easier to get behind this. But people have a problem, even if the prosecutorial misconduct is so horrible like is happening in YSL, if they really think the defendants are criminals and did commit crimes, if they think that stuff probably did happen. And from the articles I read and the stuff I see online, a lot of people are behind the fact, oh, that is a gang. They did this, they did that. I don't know, honestly. The facts have not been presented in a clear and convincing manner to me at all to learn or feel like I could vote anyway. And from what I'm seeing, and as a lawyer, you're not going to like this, maybe some people, I don't care. This type of prosecutorial misconduct cannot go on regardless of how we feel about the criminal defendant. Because if Young Thug and the rest of those defendants can get railroaded, so can you, so can I. Whether we're guilty or innocent, it doesn't matter, and then it's not America anymore. Sorry for that little sidebar there. Max Sauce brought up YSL as well. It's been a bit unhinged lately. A bit unhinged. Miranda said, do you think she is a defense attorney that doesn't know how to be a prosecutor? It seems like she is doing yucky things that a defense attorney could get away with, but looks bad on a prosecutor. I honestly think, even though she's going to deny it in here, she was out over her skis a bit and was going to win this case, was going to make sure she won this case. And to me, she's a pretty fiery lawyer. She is not afraid. She goes hard, but sometimes those lawyers can overstep too. Sometimes they can be really good and sometimes they can be really bad. Christy said, haven't been able to catch live in a while, but still watching. Thanks for all you do and keeping us informed and educated. Thank you, Christy. Right after this, we're going to redirect into a Sarah Boone update. We're going to go through those motions we kind of talked about before. It's kind of a short video. So hit the like button on this video and make sure you subscribe and make sure you got autoplay turned on for when that happens. All right, let's keep reading. It is perplexing that Mr. Baldwin would complain about pretrial publicity when it was he who elected to appear on national news and use his celebrity status to publicly lie about the facts and circumstances of Ms. Hutchins' death. Clip. The prosecution is permitted to respond to statements made by the defendant and his or her counsel to lessen the adverse impact on the adjudicatory proceedings. I don't disagree with her. I don't actually disagree with her on this part, with that sometimes it's okay for prosecutors to speak in the media as well, but it's not the same as a criminal defendant or defense attorney, and everybody knows that. She definitely knows that. In March of 23, undersigned counsel and co-special prosecutor Jason Lewis were appointed special prosecutors on all Rust-related cases and kindly reached out to Mr. Nikas and Mr. Spiro to establish a civil working relationship. After some brief introductory meetings, Mr. Nikas requested that defense counsel and counsel for the state meet in person to fully discuss the case against Mr. Baldwin, and undersigned counsel graciously and naively agreed. Isn't it great when somebody says their own actions are gracious? She graciously and naively agreed. On April 12th, Nikas and his associate Sarah Clark flew to Santa Fe, met with special prosecutors, discussed the case. During the 4-hour meeting, Nikas displayed a PowerPoint presentation that outlined his arguments against the prosecution for his client. That's good lawyering. We do stuff like all that all the time. If you can prevent your client from getting charged, that's best case scenario. During this meeting, Mr. Nikas stated that if the case proceeded, he may call a variety of A-list actors to testify on Mr. Baldwin's behalf, and specifically reference Harrison Ford and Helen Mirren. A couple things there that I think is interesting. She's going to call him a liar for this. she's going to say this was a complete misrepresentation. This was never going to happen. But when she, didn't quote him, but when she said what he said, she said he may call. He said he may call. And as every trial lawyer knows, you don't always know who you're going to call till trial happens. And we don't necessarily know how all that turned out in the background. Mr. Nikas went further and stated that if the case were to proceed, he would call Mr. Baldwin's supporting actor on Rust, Jensen Ackles, as a witness for the defense. Nikas explained Ackles would testify that even though he personally checked his prop gun for live rounds, he would not have checked if he had been in the same position as Baldwin on October 21st, 21. Nikas also asserted that Baldwin's position as producer on the film gave him power over creative decisions only, and that his contract spelled out those limitations clearly. Nearly all of Mr. Nikas' statements to counsel during the meetings of April 12th, 23 would later be determined to be false or misleading. And let's just, call a spade a spade. If you're going to lie and things like that, you should just get hammered for that, especially as a lawyer. But to bluff in a way that you present your case on best case scenario, that's how every lawyer explains their case. Best case scenario, this is how it's going to come out. I might call this guy. I might call that guy. I think they're going to be good for us. I think they're going to be good for us. That stuff changes as litigation goes. As you guys have seen, witness statements change. Maybe somebody was going to say something good. Now they're not. We've seen witnesses get impeached with depositions and under oath statements and hearings. We've seen things change since a grand jury proceeding with prosecution witnesses. So for a defense lawyer to think a witness is going to testify a certain way, it turns out he's not, so he doesn't call him, that's hardly misconduct. Now, if he knowingly made the false statement, knew that wasn't going to happen, knew these people were going to testify that way and lied about it, that's completely different. Not okay. Okay, so not surprisingly, he failed to list Ford, Mirren, or Ackles. In fact, undersigned counsel recently contacted Ackles and was notified that no one from Baldwin's defense team has ever reached out to him and requested he testify on Baldwin's behalf. That doesn't mean it wasn't going to call him, right? You don't have to reach out on their behalf, but good argument by her, right? Maybe he did just lie. Maybe his bluff was a complete lie. What does that have to do with what happened at trial and whether or not this case is going to get dismissed? These are the types of things, well, albeit maybe they have credence. I don't know. I don't know about, all these background with these celebrities and other witnesses. So maybe some of these arguments have some credibility, but what does that have to do with the motion to dismiss? This is why I think this was her swan song. She wanted to say her piece publicly. She knew people like me would be reading this. Nikas intentionally made numerous false statements in his motion to dismiss, but one of the most shocking is his assertion that the defense proved to the state that the gun used by Baldwin was modified. And again, this is kind of semantics, and we talked about it. Was it modified? Was it destroyed? Was it damaged during testing? Whose fault is it? Is that wrong? Of course, the defense lawyer is going to explain it in the way that's most favorable to him. On April 18th, Nikas emailed undersigned counsel 3 photos of the revolver. 1 photo was from the FBI examination, and the other 2 presumably came from the defense firearms expert, who has yet to be listed as a witness for the defense, despite the fact that he examined the evidence revolver of Santa Fe County Sheriff's Department and is scheduled to examine it again in the coming weeks. Nikas used these photos to convince undersigned counsel that the hammer of the revolver may have been modified because it appeared to be visibly different than similar exemplar hammers. Undersigned counsel had already retained the services of Lucian Haig, who was to be assisted by his son, Michael Haig, to perform the forensic testing on the revolver and intended to defer their examination and testing with regards to the oddity of the hammer. The Haigs are recognized nationally and internationally as experts. Preliminary hearing, he was scheduled to begin. Special prosecutors could have easily proceeded, but she's going to talk about now how they kind of paused it in order for them to do more testing on the gun, and they basically did that. This was, I just want to, oops. So there's a bunch of things that they added to this, but I want to make sure this is Morrissey that did this. Yes, okay, it was. Okay, good. So, all right, let's see here. Shoot, where was I? And it's just, again, it's so interesting to look back now and see what she was saying months ago before the trial even started, the types of allegations that she was hurling at Baldwin and his team. Okay, they extended the deadline. Yeah. Somebody said check the date on this filing. Yeah. So this was before the trial. All these comments she was making about the defense attorney, and that's why I think it's interesting to look back now, 2020 vision, knowing that the case was thrown out. And that's what I find interesting about this document itself. As disturbing as this information was, undersigned counsel was not inclined to rescind the plea offer simply because Baldwin intended to continue to use the media to escape the consequences. It was at this point that the plea offer was rescinded and the case was scheduled for the grand jury. Still, Mr. Baldwin complains that this court has been treated unfairly, that he's been treated unfairly. It is worth noting that the plea offer was rescinded. The news reporter again contacted undersigned counsel and warned her that the reporter spoke to Mr. Nikas about the retraction of the plea, and Mr. Nikas explained he was going to destroy undersigned counsel. Okay, so it's giving us all of these kind of background information, things that happen in the back rooms, things that we didn't necessarily know about, and she explains them all in this motion. All right. And through these pages, she goes through point by point how gracious she was. She talks about plea offers that she makes to Hannah Gutierrez Reed. She talks about plea offers that she makes to Alec Baldwin. She talks about how she tried to handle all of this appropriately. Okay. None of this mattering, right? None of this ending up mattering at the end of the day. I guess she's never heard two wrongs don't make it right. Well, ain't that the truth? K-Rab said, if you think people aren't outraged by YSL, you aren't watching the channels covering it. Try Nick Stero. Yes, and Nick is here a lot as well, and he is covering that. SC said the $50 million OceanGate lawsuit that no one has covered yet. I haven't seen that. The defense team, asked for all of these modifications. They complained about contact with the press when they're the ones contacting the press. Then they argue a little bit about the grand jury proceedings. The grand jury proceedings that Nikas argues about, she says he doesn't understand how they work in New Mexico. She doesn't understand how they work in this state. And frankly, most grand jury arguments by criminal defense attorneys don't do great, not usually going to be a reason that they win. And she was right. That didn't end up being a big deal, right? A lot of what Baldwin's team argued didn't end up being a big deal because the Brady violations, the body cam footage, the witnesses that came forward, the evidence that they had that they hid, it is just crazy to think that Baldwin and his team were making these arguments way back when. And Morrissey had the gumption to say things like this is really, really wild to me. And then the other thing that's interesting, after we get through this, we'll kind of compare it and talk about the filing that happened recently with Hannah Gutierrez Reed's case and how Morrissey continued to do much of the same. So then they talk about how they kind of got rid of the judge, even though the judge was doing everything that the defense team wanted them to. And the defense team presented all this stuff to the grand jury the prosecution presented all this stuff to the grand jury that the defense team wanted to. They agreed to do that, all this stuff. Let me see here. She calls them a liar some more. It's really, really wild. All right. So now let's jump over to the Hannah Gutierrez Reed one. So these two documents were each basically 30-some pages. I'm trying to keep it to about 30 pages total that I read through. Is this it? I think this is it. Yes. All right, here we go. All right. So now, Defendant Gutierrez seems to complain of 4 issues that she alleges support her motion for new trial. First, defendant argues generally argues that undersigned counsel lied under oath during a motion hearing during the trial against Mr. Baldwin and failed to disclose the existence of ammunition that was obtained from her father's close friend, Troy Meskey. Second, the defendant raises concerns regarding an audio recorded interview with Seth Kenney that was not disclosed until after her trial. Third, Ms. Gutierrez asserts that she should be granted a new trial because supplemental report produced by Lucian Haig on August 31st, 2023 was not provided to her or her counsel prior to trial. Fourth, Gutierrez asserts that she should be granted a new trial because there are unremarkable email communications between the state and experts Lucian Haig and Brian Carpenter that were not disclosed to defense prior to trial. So what's interesting just right off the jump with this, is she is throwing this all away. No big deal, not happening. But it's just more and more stuff that the state did not turn over. It's more stuff the defense is finding out about after the fact. It's more stuff the defense should have and needs in order to properly represent their client, to properly understand what's going on in the case, to be able to cross-examine witnesses, to be able to figure out if there's an actual problem with some of the evidence that they're presenting. This stuff needs to be turned over. Now, she makes some good arguments. I will give her that. Through this document we're going to go through, she makes some good arguments about why this stuff might not be material, why it might not even have been something they need to turn over, and why it might not prejudice Gutierrez Reed, which we know there are big differences between Gutierrez Reed's case and Alec Baldwin's case, especially when it comes to the ammunition. So let's take a look at some of her arguments. Undersigned counsel did not lie under oath. She testified that she was aware of Mr. Teskey provided ammunition. She further testified she was not aware of the doc report outlining the fact that the ammunition had been provided to the sheriff's department did not contain the same case number or would not be linked to the same case number of the rest of the evidence of the Rust investigation. This right here is so bad. It is so bad that, yes, please send me the Ocean Gate docs. I'll definitely take a look at that. It is so bad that this stuff was not only not turned over, but buried. So even if you were to order something or try to find something or make a public records request with this case number, you would never be able to because of how they did this. This was a true statement, and undersigned counsel qualified her statement during cross-examination by explaining that she misunderstood that the doc report would have a different case number assigned because she is not a law enforcement officer and doesn't work at the sheriff's department. Corporal Hancock understood that the new doc report would have a different case number because it was a separate doc report. Undersigned counsel did not understand that doc reports have different case numbers due to her lack of familiarity with the manner in which case numbers are assigned to the sheriff's department. Undersigned counsel and Corporal Hancock testified truthfully. So that to me sounds a little bit like her throwing Corporal Hancock under the bus, which she has no problem doing. Undersigned counsel testified truthfully when asked why Ms. Johnson withdrew from the case during the motion hearing prior to the lunch break on July 12, 2024, without hearing any of the testimony or argument related to Defendant Baldwin's motion to dismiss. The court went off the record and notified undersigned counsel and Mr. Spiro that she was intending to dismiss the case. Undersigned counsel and Ms. Johnson discussed the issue at great length over the lunch hour. So, just as we thought, Morrissey knew, just like we did at that point, the court was going to dismiss the case. She was going to throw it out. So Morrissey testified knowing it was going to get thrown out, which just boggles my mind. Why you'd even open yourself up to these accusations that you lied under oath on the stand. You didn't need to. It was totally unnecessary. You knew you were going to lose at that point. Undersigned counsel and Ms. Johnson discussed it over the lunch hour. Based on the court's off-record statement, it was apparent the court was intending to dismiss the case so that the state had two choices. One, dismiss the case on its own volition, which it sounds like that's what Ms. Johnson wanted to do. Or two, have a full hearing, develop a record, and let the court dismiss the case. Ms. Johnson wanted the state to dismiss the case, and stated that she wanted the case dismissed out of concerns for self-preservation. Undersigned counsel disagreed that self-preservation was an appropriate reason to dismiss a homicide case. So did you catch this? Erlinda Johnson wanted the state to dismiss the case because she cared about self-preservation. So we're hearing her take shots at defense lawyers, at the judge, at her co-counsel. Undersigned counsel disagreed. So she's saying, I did the honorable thing. I did the right thing. I stood up there for justice, and Ms. Johnson did the wrong thing. Sounds like what Ms. Johnson said, that she wanted to dismiss the case, is still true and correct. But they disagreed. Ms. Johnson did not want a public hearing out of concerns, again, for self-preservation. Undersigned counsel testified truthfully in this regard. Undersigned counsel has not had a win at all costs attitude in the Rust cases. In fact, it's been the opposite. Mr. Bowles knows it. Here we go. They attempted to resolve Gutierrez's case, just like she talked about prior multiple times. She attempted to resolve Baldwin's case, meaning I offered him plea deals. I was so gracious. They didn't think they committed a crime, but I was so gracious to say, just admit that you committed a crime you don't think you committed, and you can have this plea deal. Regardless of what we think, regardless of what happened at trial, if you believe you're innocent, you shouldn't be forced to take a plea deal. It's not gracious of the state to offer you a plea deal if you believe you're innocent. Now, would it have been better for Hannah Gutierrez? Sure. Then how it ended up? Sure. Well, maybe she'll win this and get out. They wanted to put the plea deal on the record. Court declined to do that, but they wanted to make sure it was a knowing no to the plea agreement by Hannah Gutierrez. Undersigned counsel testified truthfully with regard to the termination of the previous paralegal assigned to the Rust cases. Mr. Taub's work was unsatisfactory. Okay, Mr. Taub, welcome to the team. You're getting thrown under the bus too. And a decision was made that his work would cease after the conclusion of the Gutierrez trial. Undersigned counsel stopped assigning him tasks due to poor quality of his work. Taub complained about the working conditions as related to another employee at the district attorney's office who he had difficulty getting along with, but never complained about undersigned counsel. Never complained about me, Judge. It should be noted that Mr. Bowles made mention of emails and an affidavit concerning the issue of Mr. Taub's termination, but attached none as exhibits to his motion. Undersigned counsel will move to strike, or in the alternative, request leave to submit supplemental briefing should Mr. Bowles decide to submit an email affidavits exhibit to his reply. How else did undersigned counsel testify truthfully? Well, she testified truthfully that Mr. Bowles did not want the Teskey rounds. And this is where I see a major difference between the Gutierrez and the Baldwin trials. During the brief statement Teskey made while providing the ammunition to the sheriff's department, he stated that he was asked by defense counsel Bowles to testify on Gutierrez's behalf and bring the ammunition in his possession to the Gutierrez trial. Teskey did as he was asked to do. Mr. Bowles declined to call him as a witness and did not use the ammunition Mr. Bowles asked him to bring from Arizona. So if this is true, this is where I see a difference where Baldwin's team didn't even know about it, had no way to know about it, and it was buried. But Bowles brought Teskey, knew about Teskey, chose not to use him at trial, which I think at least for the prong of prejudice, like, did this prejudice you? Would this have changed it from guilty to not guilty? You didn't even think so because you didn't even call him when you knew existed. Still wrongdoing on the state, but we do have to hit all those prongs. It's stunning that Mr. Bowles now claims that his client was somehow prejudiced by the state's failure to disclose ammunition that was not in the state's possession, but was in the possession of a defense witness and was available to defense counsel. The January 8th, 2024 email referenced by Mr. Bowles had 4 photos of the Teskey ammunition attached. Bowles provided these photos to undersigned counsel. The photos depicted 4 rounds that had brass primers, only one had Starline brass casing, and all had projectiles dissimilar to the rounds found on the set of Rush. Mr. Bowles is the person who provided undersigned counsel with the information that caused her to abandon any effort to obtain the test rounds in the case. The only information undersigned counsel had about the Teskey rounds was the information provided by Mr. Bowles and Mr. Teskey, and all the information was that the rounds in Teskey's possession were dissimilar to the rounds from Rust. Then they go through the different types of ammunition, how the ammunition actually came from Thel Reed, not from Seth Kenny. There's a bunch of pictures of them in here as well. And the photos were provided, some of them by Mr. Bowles. The exact rounds here. To be clear, the ammunition in Teskey's possession was owned by Thel Reed. No evidence that it ever left Arizona. And all this is great and good as to why you didn't use it. But you still got to produce it to Baldwin's team. You have to. If the first time you found out about it was during Hannah Gutierrez's case and Bowles knew about it, you weren't going to use it and Bowles wasn't going to use it, I understand her argument there. And again, that's where the difference lies between Reed and Baldwin. D-Dub said, all her references of how outrageous it is that Baldwin had 8 lawyers makes me think everyone needs 8 lawyers. It's so unfair for the prosecutors. Yeah. And it also, when you think about Sarah Boone's situation and they're really trying to help her out, telling her, hey, this is a good expert you might want to try. Would you want to take that expert if you were the defendant? Judge, the defense attorneys are trying too hard to defend their clients. Yeah. Come on. Who wants that? Who wants that? Shaylin said, Carrie is burning the boat while still on it. Mike said, I would take Morrissey as my defense lawyer. Maybe, maybe not. Go Peter, you are rightly fired up. I mean, it's just wild that for months and really throughout this case, back to the Hannah Reid trial, back to prior motions we're reading, this motion, the language and hyperbole she uses is just so interesting to me with 2020 vision, looking back now that we know how it all happened. Sophia said, off topic, Joel at SDS is starstruck by you. Highly, highly doubt that. Said he's nervous if he sees you at Sarah Boone and may get an autograph. Stop. That's not true. He's blowing smoke. That is not true. Runkle, what's up, man? She's not getting disbarred. Yeah, I would not think she's getting disbarred over this. I do not think she's getting. But a lot of people were sending me things saying, yeah, she got disbarred, her license taken away. I would be floored if that happened, which unfortunately should show you how low the bar is for attorneys. But I mean, I think she could get potentially publicly reprimanded and things like that if it continues down this road. I do. Rounds were not in the state's possession until March 6th. Again, more photos below, just kind of how they got them. Never in the possession of Seth Kenney. No evidence these rounds were ever in possession of Seth Kenney. As discussed on July 12th at the Baldwin motion hearing, Gutierrez photographed herself in possession of live rounds, which is fine. I want to get to the part where... Yeah, then she says, it's worth noting that sending ammunition to the FBI for testing is not determinative of whether the same ammunition on the set of Rose. It's like, yeah, but you tested all this other ammunition. It was relevant enough. So what's happening here? Why are we acting like there's no way this could have been relevant? It definitely could have been relevant. Would it have been relevant? Would it have been helpful to Hannah Gutierrez? Probably not. But that's why it's a little less egregious than in the Baldwin case. The answer to Ms. Gutierrez's question is twofold. First, the question assumes that the court properly dismissed the case against Mr. Baldwin, and we know she doesn't think that's true. Although the court's final order has not yet been filed, undersigned counsel contends that the court misunderstood the testimony. So again, court, bus, let me throw you under it. You just misunderstood, Judge. Let me help you. Although the court's final order, so the court improperly dismissed the case. For the case against Mr. Baldwin to be properly dismissed for a Brady violation, the court needs to find the following. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. And that evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. Absolutely willfully suppressed. No way you'll ever get me to say anything other than this was willfully suppressed by the state and law enforcement together. Now, was it exculpatory? I think it was potentially exculpatory. But I don't know for a fact that it was exculpatory. And the fact was they never turned it over for the defense to test. They didn't turn it over for them to impeach any FBI witnesses or anything about it. And they had all this prior to trial and willfully suppressed it. That, in my opinion, is enough for a Brady violation. And then she goes through Baldwin's charged with violating the rules promulgated to ensure firearms. She cites some SAG rules in here too. Never put your finger on the trigger till you're ready to fire the firearm, things like that. Case was dismissed due to the state's failure to disclose the ammunition. And based on what he's charged with, she's saying it wouldn't have been exculpatory. Nobody would have thought it was a big deal. No evidence. Again, Kenny. I thought there was a part. Second, if the court were to decide that the dismissal of the case against Baldwin was proper, there is one huge difference. In the Gutierrez case, the state was not in possession of the Teskey ammunition prior to trial, although arguably Mr. Bowles was. In the Baldwin case, the state was in possession of the Teskey ammunition. Mr. Bowles is comparing apples to oranges and trying to make a square peg fit into a round hole. I do agree with that argument. I do. And that's what we said immediately when people started asking about, was this the same thing that's going to happen in Gutierrez's case? It could affect the case, but it's not exactly the same. Undisclosed interview of Seth Kenny, I thought was kind of a nothing burger. Same thing with the Hague report. Again, not a big deal to me. Don't have time to kind of go through all this as well. All right, but I did want to get to the argument here. As outlined above, meeting the following three requirements establishes a Brady violation. The evidence at issue must be favorable to the accused, either because it's exculpatory or because it is impeaching. And that's the thing with Baldwin. That stuff could have been used to impeach other witnesses. The evidence at issue must be favorable. Sorry, I already read that. The evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. While this is not the law that controls whether a defendant is granted a new trial, the state will address it briefly because it is argued in the defendant's motion. There is nothing about undersigned counsel's testimony with regard to Ms. Johnson's departure from the prosecution team that is at all relevant to Ms. Gutierrez's motion for new trial. I agree with her. There is nor is there anything relevant to undersigned counsel's statement with regard to Mr. Taub's departure from the prosecution team. I agree with that, except I guess that you're saying if there's like, they're trying to build that there's like a systemic problem here, which I get that. Likewise, there's nothing relevant about the circumstances related to the doc report and the case number assigned to the report that Teskey rounds that is relevant to Ms. Gutierrez's motion for new trial, as evidence at issue was not in the possession of the state until the end of Gutierrez's trial and not prior to the trial. Moreover, all testimony provided by undersigned counsel with regard to Ms. Bowles' lack of inherent or interest in the Teskey ammunition is based entirely on Mr. Teskey's own statement during his brief encounter with law enforcement on March 6, 2024. The undisclosed interview of Mr. Kenny is not exculpatory or impeaching, and its suppression did not result in prejudice to Ms. Gutierrez for all the reasons outlined above. And while those things are kind of a nothing burger, right? The report, the interview, why does she have to suppress that stuff? Why can't she get it? Why can't she just turn that stuff over? The undisclosed Hague report is not exculpatory or impeaching. Mr. Hague has consistently opined that the gun fired Mr. Baldwin functioned properly. Moreover, Mr. Hague has since gathered additional information about the history of the gun, the FBI testing, and is now of the opinion that the microscopic tool marks were the result of the FBI's accidental discharge testing. The state agrees generally with the defendant's recitation of the law with regard to its disclosure obligations under 5501 and agrees that any witness statement that was not disclosed pursuant to 5501 was an inadvertent violation of 5501. So she's agreeing that they inadvertently. All right, hold on. A bunch of people are saying, look at the chat, look at the chat, look at the chat. Okay. Kelsey, are you looking at the chat? Because it's hard for me to read and look at the chat. You've got some troll issues. Toss me a wrench. I don't know how to do that. John, do you know how to do that? I don't know how to do that. I don't know how to do anything on this, guys. Come on. Can we get a big woof from lawyer you know? I wish I did know how to do that. I don't know how to do that. Okay, they're saying they're watching. So I don't know. I have not been watching the chat. Sorry. It's really hard for me to watch the chat while I'm reading at the same time. I love multitasking, but that's tough. Please cover Corey Richins. That's on our list as well. And Karen Reed tomorrow. I'm completely sidetracked at this point. Let's get through this. We're almost done. And if I knew how to give Runkle that power and that wand, I would. Okay. Question from this court at this juncture is not controlled by 5501, but rather by 6 factors the court is required to consider when determining whether a defendant should be granted a new trial. Number 1, that the discovered evidence must probably change the result of the new trial if granted. That's important. Was discovered after the trial. That's important. Could not have been discovered before the trial by the exercise of due diligence, is material, is not merely cumulative, is not merely impeaching or contradictory. So again, this is different than the Brady violation to dismiss the case. It's very different. I have two, TJ. I have two. They're watching. I don't know if we missed something, but they're watching for sure. The analysis applies only to the undisclosed interview by Seth Kenney and the undisclosed report from Lucian Hague from August 31st, 2024. The state concedes that the second prong of the 6-prong test has been met with both the interview and the report discovered after the trial. So those two things, she admits, were discovered after trial. The Kenney interview, would the interview likely change the jury's guilty verdict if a new trial were granted? There's no indication that the existence of the interview of Mr. Kenney would change the result of a new trial if a new trial were granted. The majority of the statements made by Mr. Kenney during the interview are cumulative and are based on text messages that have been in defendant's possession since the inception of the case. So this is one of those situations where maybe it was something new or different, but it didn't actually bring any new or different information to the table. Maybe. Statements 1, 5, 6, 9, 14, 15, and 17 were all previously in the possession of the defense by way of text message and other statements by Mr. Kenney that were in possession of the defendant. Statements 2, 8, 10, and 20 were statements that easily could have been obtained if the defense had simply asked the pointed questions during the pretrial interview of Mr. Kenney. Specifically, statement 2, as it related to Ms. Gutierrez's experience in the film industry, was in her possession and her resume was in the discovery provided to the defense. Kind of agree there. If the defense wanted to know her experience compared to Mr. Kenney's, all they had to do was ask him during his pretrial interview or at trial. Yeah, but that's not really a fair representation of material that should still be turned over. And I still think they should have turned this over. I just don't know if it rises to the level of a new trial, because would it have been likely to change the jury's vote? And that's why winning these motions for new trial are so difficult. So difficult. However, given that Mr. Kenney was not on trial and did not work on the set of Rust, it is unlikely that his experience would have been material at Ms. Gutierrez's trial. Mr. Kenney is simply a vendor. Any training deficiency suffered by Ms. Gutierrez would be the fault of her trainer, Thel Reed. Okay, just for her to throw that in there. Similarly, concerning statement 8, if Mr. Bowles had questions about statements in the search warrants as they related to Mr. Kenney or PDQ props, all he had to do was ask Mr. Kenney. Statements 10 and 20 are related to the theory of sabotage and was well known to the defense long before trial. And the defense could have easily questioned Mr. Kenney about his theories with regard to sabotage. Statements 3, 4, 7, and 19 were all cumulative and consistent with the well-known evidence in the case statements. Case and statements 11, 12, 13, and 18 are immaterial and inadmissible, therefore making them immaterial. At best, Ms. Gutierrez is able to meet 1 out of the 6-prong test for new trial. All right, now the Hague report. The state concedes that the defendant can meet second prong. However, the Hague report will not likely change the guilty verdict at the trial, given that Mr. Hague always opined that I think she means firearm functioned properly. The issues related to the tool marks on top of the sear and the existence of the report could have been discovered if the defense simply asked Mr. Hague, how many reports did you provide to the state in this case? Again, that is a horrible answer. I totally disagree with her there. The defense figuring out that stuff exists that the state already knows exists and is hiding is not the way it's supposed to work here. But I do agree with her. It probably wouldn't have changed the vote from guilty to not guilty. But will we ever know? I don't know. The issues, sorry, we did that. This question wasn't asked in part because Mr. Bowles did not attend the vast majority of pretrial interviews, to include Mr. Hague's interview. This material could also have been discovered by simply having the defendant's own expert review the photos taken by Mr. Hague that clearly show the tool mark on top of the sear, or by having the defendant expert examine the gun. Moreover, the statements in Mr. Hague's report that Mr. Bowles makes issue of are merely impeaching, as Mr. Hague modified his opinion specifically with regard to the August 31st, 2024 report after obtaining additional information about the gun and the FBI testing of the gun. That's important. Anytime you can impeach an expert witness, that's important. Come on. Would it have changed the vote? I will just tell you, usually a minor impeachment about something like that isn't going to rise to the level of a new trial. Now, with all this other stuff, and that's probably why Bowles threw all the other stuff in his motion about what happened in the Baldwin trial and the problems with the staff and everybody leaving and bailing on Miss Morrissey and Miss Morrissey, lying under oath, according to him. That's probably why he piled all that on, because he's trying to make a mountain out of this with the problems, because individually, I'm not sure any of these things are enough to grant a motion for new trial. What does Runkle say? Did Runkle think it was enough? I'd be interested to hear his thought on this in the comments if he does. If he did, or you guys already saw it, let me know. With regard to the defendant's arguments that she should be released pending appeal, state hereby incorporates all the arguments submitted in its response to the defendant's motion for release pending appeal filed May 27th. And there's Carrie Morrissey at the bottom. Whew. That was a lot. I know people were like, he was moving fast. I got a 4 o'clock. So I had to be done by 4 o'clock. So that's why we are going to be done by 4 o'clock. But questions, comments, now we can go. Corey Richens not allowing streaming. Hope your uncle can catch us up later. Ooh, that's interesting. I must have missed that. I didn't know they weren't allowing streaming. Yeah, the stuff seemingly coming up is Richens, Karen Reed stuff still happening. Somebody sent me something on Chad Daybell. I don't know if you guys want me to still cover that. A bunch of kind of like one-off things, but Sarah Boone and Richens seem like they're working their way down, and maybe Sarah Boone will go to trial. That'll be wild. Have you ever seen an attorney behave like this? Yes. I have seen this stuff. Stuff like this, or saying lawyers are misrepresenting or making false statements. To me, that absolutely is something that happens in motions. I wish it didn't, but it does. And the best is when they attach emails. They attach emails like, look what this person said. That's why I always say, I tell my lawyers, and we've all talked with each other about this, write an email as if you expect it to be an exhibit in a motion. He's probably busy modding. Well, I see his comments coming through now. Okay. I don't think they're getting a new trial here. The main thing is the ammo, and Bowles had that. I agree. I think he's throwing more smoke than he's actually got. Right. And I think there's like a wave of support and everybody not liking Morrissey or the prosecutors at this point, or, the judge being against them, and he's trying to jump on that wave and ride it. But I just don't think he's got the same goods that Baldwin's attorney had, because of the different circumstances, different cases, different timing, things like that. My first super chat was about the first motion you read. Yes, I got that, Kate. I did. It's old. Jason Lewis, special prosecutor, stepped down in April. Correct. Corey, you do you, Peter. We're here for the content, not the attention seekers for whom ignoring will likely dispel their patient's brother. I didn't see it. I think I missed it. I saw one guy that I did block who was like, those who can't do or on YouTube or something like that, which cool, man. Whatever you got to say, I do what I like to do, in court, in real life, on YouTube. That's what makes it fun. That's what makes it so fun. Yes, I saw Runkle's post there. Just saw you. The gist, if I'm correct. So, Your Honor, my gatekeeping of information would have no effect on the verdict. So, although unethical, but it would have changed anything anyway. And, Jill, the one thing you're missing is all the defense had to do was ask the right questions. Why didn't you ask about the information you did not know existed? Shouldn't you just have asked? And if you would have asked, you would have found out. Ginny said YSL is off the rails. Yeah, I mean, that is, I know I say all these trials we watch together are not normal. That one very specifically is not normal. Yes, thank you, Runkle, for sharing your thoughts. I think the Daybell has new attorney claiming inefficient assistant counsel. So nobody should be surprised at that. Basically, every criminal case eventually gets there. It's either one of the first or one of the last arguments they make. Ineffective assistance of counsel. No lawyers, especially public defenders, really take offense to that. I know Daybell didn't have a public defender, but you want your client, if you believe he's innocent, to go free, not be in prison for the rest of his life. So if it happens that the court found that you were ineffective and he needs a new trial because of that, so be it. We want justice. We want fairness. We don't want, them to lose ineffective assistance of counsel if we really were ineffective, just not to sully our name. At least I'll just say that for me. Watching Richens on RA. Okay. So they're watching on Recovery Addict. So I guess it's not. I guess it's not being streamed, so we'll have to follow that. She should definitely be sanctioned. Oh, sorry, Commonwealth. I think CW. I don't know what CW means. I'm blanking. I'm just all that pops in my head is Commonwealth. Thanks to Karen Reed. But we'll see. We'll see what kind of complaints come. We'll see if she gets sanctioned. I feel like Baldwin and his attorneys are for sure going to file some civil lawsuits. So we'll have to see how all that goes. All right. So yeah, Karen Reed tomorrow is at 2 p.m. I've seen 1:45. I've seen 2 p.m. I'm not live streaming it. I'll do a recap either Friday night or Saturday morning, recapping that, breaking all that down. I've got to figure it all out with the family schedule Friday night and this weekend. I never have any idea what's going on. My wife tells me what's going on. I pretend to know what's going on because I'm sure it's not the first time she's told me, but I'll have to figure it out to see if I can stream Friday night or Saturday morning. But our hangout time is not quite over because in about 2 minutes, it's going to automatically redirect you into about a 15, 20-minute video on Sarah Boone where we go through those 3 motions she filed. Handwritten motions, some of them granted, some of them waited, being pushed to another time. And we're going to go through what we think is going to happen with those. Is she going to win? Is she going to lose? Does she need more details? We'll go through all that, all those motions together. If you guys want to stay and hang out for that, make sure you hit the like button on this video. Make sure you hit the like button on the next video when you get there. And we also have a very interesting short coming probably tonight on the YSL trial because that's the trial that never sleeps. More stuff always happening. Okay. I think I got to it all. A little out of breath. That was a lot of reading, a lot of hanging out. Glad we were able to do it. You guys are the best, literally. Keep telling me what you want to hear. That's how we figure out our content. And you're the ones that make it happen. Lauren and all the other new members, welcome. Thanks for joining us. August is always a fun members only video because we do our fantasy football draft for anybody that's into that. Awesome. So check out our community page. If you're interested in fantasy football, you can figure out how to be selected to join our league. All right. That's it. Thank you guys so much. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.